We are going to go ahead with the meetings, particularly the annual general meeting. First, we'll see what are the different types of meeting, and then we'll see in details how the annual general meeting is conducted. Okay. So any doubts, we will keep it till the end. Okay. Now, there are different types of meeting. The first meeting is called the general meeting, which is also called the annual general meeting or AGM. There is also an extraordinary general meeting. So what is an annual general meeting? So it is a mandatory yearly gathering of a company's interested shareholders. Okay. And the main objective of holding an annual general meeting is to give an opportunity to all the members or the shareholders to discuss the functioning of the company and also to take steps to protect the interest of the shareholders. So they can discuss any matter which is relating to the conduct of the affairs of the company during the annual general meeting. And in an extraordinary general meeting, it can be defined again as a meeting of the shareholders, which is not an annual general meeting. So there are two types of general meeting, which is one is annual general meeting and the other one is extraordinary annual general meeting. Okay. The main aim of again holding an EGM, extraordinary general meeting, is basically to discuss any matter of urgent importance, any matter which is very, very important, urgent importance, that is why it is called, and which cannot be postponed or the company cannot wait till the conduction of the next annual general meeting, or something which is so urgent that it needs the immediate attention of the shareholders. Okay. Okay. Then apart from the annual general meeting, we have the board meetings. So board meeting is the meeting of the board of directors of the company. And who are the board of directors of company? We have already seen in the last class. And then there is the class meeting. So it is the meeting of a special class of persons, maybe like your preference shareholders or maybe creditors. Okay. So these are the different types of meeting, out of which our basic focus should be on the annual general meeting. Okay. So basically, here constitution means your articles of association is going to give guidance about the how you are going to hold the annual general meeting and everything. Okay. Now let's come to next is notice of a meeting. Now section 101 of the Companies Act 2013 states that to properly call an annual general meeting, a notice of at least 21 clear days should be given. Please, all of you write down 21 clear days. Clear days I'm mentioning. Okay. So before the meeting, it has to be sent to the members before the meeting. It should be given to all the shareholders or the members or the legal representative of any shareholder who is deceased. That means if a shareholder has expired or died, then his legal representative, okay, legal heir that we could say, or the assignee of an insolvent member. So if a person has become insolvent, then the court will appoint an assignee. So the notice of the meeting has to be sent to the assignee also. It has to be given to the auditors, directors, and this has to be given both in writing or electronic mode or any other mode as prescribed by if your article has authorized, then you can give it in any other mode. Okay. So it is both in writing, electronic mode, or any other prescribed mode. And 21 clear days. So I'll come to the meaning of 21 clear days. So over here, there are two things that I want you people to note it down. One is 21 clear days. What is the meaning of 21 clear days that I'll be discussing? And the second one is electronic mode. Okay. So Rule 18 of the company's management and administration rule, there is something like this, 2014, they have mandated or recognized sending of notices through electronic mode. Earlier, it was not like this. Okay. So Rule 18 of Companies Management and Administration Rule 2014, that gave the mandate of, for sending notices through electronic mode. Okay. And for the purpose of this particular rule, Rule 18, if we say the expression electronic mode will mean any communication which has been sent by the company through its authorized and secured computer. Okay. Computer which is capable of producing confirmation and keeping a record of such communication. Okay. So basically it is from, you can say, the company's electronic mail address. The notice of the meeting can be sent. So there they have described in a better manner where they are saying that it has to be authorized through a secured computer. But when you try to understand the meaning of that, it is basically from authorized email ID of the company. Okay. And this has actually gone a long way in helping the companies, particularly during the COVID time. Okay. So that is very, very important. Then second, I told you to write down 21 clear days. What is the meaning of 21 clear days? It means the date on which the notice is served and the date of the meeting. Okay, the date on which you are sending the notice and the date of the meeting, both are excluded for sending the notice. Okay, so a company cannot curtail the requirement of 21 days through its articles also. Okay, so it cannot reduce that day of 21 days in any manner. They cannot. 21 clear days is mandatory. Okay. Now, who is entitled to receive the notice of the annual general meeting? It is the members, the legal representatives, the auditors, the directors, okay, the assignee, or any other such person who the company thinks is entitled for the meeting. Okay? Okay. Now, I have already told you that 21 clear days has to be given, and the law has specified that a period less than 21 days cannot be mandated in the Articles of Association. That means Articles of Association cannot say that, okay, we want the notice period to be 8 days or 10 days. That is not possible. Okay? But a general meeting can be called in certain times after giving a shorter notice also. Okay. It can be, that notice can be given either in writing or in electronic mode or in any other mode as specified by the article. This is also possible. Where is it possible? It is possible in the case where an annual general meeting by not less than 95% of the members entitled to vote threaten. Okay. just a second. Sorry, where 95% of the members entitled 3H, and in any case, any other general meeting of the company can be held if the company, like the if the company has, holding company has in the subsidiary company majority number of shares, then there also they can keep. But these can only take place in case of certain emergency where the resolution for the same has to be passed to conduct such a meeting, where 21 clear days is not required. Okay. Then where is the venue of the meeting? The venue needs to be accessible as possible. You cannot keep a venue which is very far away or which is not accessible by the members of, or the shareholders, the majority shareholders. Okay. So basically, usually what practice has been seen is that it is not mandatory, but the practice that has been seen is the venue is usually where the company's registered offices. But it is not mandatory that the company will hold the annual general meeting over there. It is only the practice. Okay. Now, few other things that is under the annual general meeting. So under the annual general meeting, I want you to write down two things. One is ordinary business, one is special business. Okay. The Companies Act has set out two types of businesses that are to be transacted in the general meetings, annual general meetings. One is ordinary business and the second one is special business. Please write these two down. Okay. So by ordinary business,
ma'am, what are these?
Okay, these are the two businesses. That means what dealings you are going to, why are you calling the meeting? What is the need for the meeting? Okay, when you are calling a meeting, when you are calling an annual general meeting, what is the business that you are going to transact in there? What are the businesses that are going to take place in that meeting? Okay, so the Companies Act has divided it into ordinary business and second one is special business. Okay.
Yes, ma'am.
Okay. So ordinary business, what are the things that are to be taking place in ordinary business? Okay. One is consideration of the financial statements. Please write down. Consideration of financial statements and the reports of the board of directors. Under ordinary business, first is consideration of financial business and reports of board of directors. Second is declaration of any dividend. Okay. Third is appointment of directors in place of the retiring directors.
Ma'am, again, please.
Appointment of directors in place of retiring directors. And fourth is appointment and fixing the remuneration of auditors.
Ma'am, fourth again.
Fourth is appointment and fixing of the remuneration of auditors. Okay. So these are the most important business which come under ordinary business. Okay. Any other business or any other decisions or anything else that is discussed thereat in the annual general meeting, they are termed as special business. Anything else. So apart from these four, anything else will be termed as special business. Okay. Now, another provision over here is explanatory statements are not required in case of ordinary business. But in case of special business, explanatory statements are required. Okay. Another provision under the Companies Act, which is there in section 102. Okay. It states that if the special business which are being discussed in the annual general meeting, they relate to or affect any other company. Okay. The extent of shareholding in that other company of the promoters, directors, managers has to be disclosed. If the shareholding is 2% or more of the paid up share capital. Please keep yourself muted. I don't want anybody. Okay. Please keep yourself muted. Okay. So, section 102 is saying that supposing any other business is being discussed about any other company, then immediately, then that will first of all go under special business. Point number one. Point number two is that then if any promoter, director or manager who has an interest in that other company, and if the interest is a shareholding of 2% or more in the paid up share capital, then it has to be disclosed immediately in the annual general meeting. Why is it essential to disclose this? So that the shareholders will have a fair idea about what is the need for discussion about the other company and what is the pecuniary interest of any promoter or director in that other company, so that it will give them a clear, fair view, and accordingly decisions can be taken. Okay. I hope everybody has understood this. Okay.
Oh, ma'am, repeat again, please.
Yes, ma'am.
Okay. See, there is a provision in the, so everybody has understood ordinary business and special business. Ordinary
Yes,
business consists of only those four. Apart from those four, anything else that is being discussed will be called a special business. Okay. Now in special business, supposing there is a topic relating to another company. Okay. And that other company, if you are discussing, then it is mandatory on the part of the promoters, shareholders, or anybody, okay, who has an interest in that company. What kind of interest? Has an interest of at least 2%. He in that other company, he is having a share capital of 2% or more, paid up share capital. Okay. Then you have to disclose about that company and your interest in that company to or in front of the annual general meeting, so that whatever decisions are going to be taken, all the shareholders will understand the reality behind the company, the relationship with the company, and accordingly a free and fair decision can be taken. Okay. Understood?
Yes, ma'am.
Now, if you don't disclose, now section 102 is saying that you have to disclose. Now, if you do not disclose, then what is the result of non-disclosure or insufficient disclosure in the explanatory statement? Then any benefit that arises to the promoter or the director or manager or any other key managerial person or their relatives, okay, then that action can be taken against such a person under this act or any other law which is at present in force. And he can be liable to compensate to the company to the extent of benefit that he has taken. Okay? So, for example, the annual general meeting of XYZ company is taking place. I am a director, but I'm also interested. There is another company, ABC. I am having a 10% share over there, and I want that company ABC to get a particular tender from this XYZ company. If I have to do that, then I have to disclose in front of the annual general meeting that I am a shareholder in ABC company. If I do not disclose, then whatever profit I am making, okay, that action can be taken against me under the act or any other act, okay. And second is I might have to compensate the company for the benefits, if any, I have received from ABC company. Okay? So, Companies Act is pretty strict when it comes to with regards to when it comes to penalties and disclosures. They have said certain disclosures are mandatory, and if the disclosures are not within the framework, then the Companies Act is very strict about the penalties that are imposed. Okay. Another point which I don't. Okay. Another point which I've missed out over here is the quorum for the meeting. Okay. Quorum means the minimum number of members who have to be present to have a valid meeting. Minimum number of members. So in a public company, first let us see the public company. Okay, in a public company, if the number of members is not more than 1,000, then quorum will be 5 members who are personally present, not proxy. All of you know what is the meaning of proxy. I won't go into the meaning of proxy. Okay. So if the number of members is not more than 1,000, then the quorum shall be 5 members who are personally present. This I'm talking about public companies. Please write it down also. So if the number of members is more than 1,000, but it is up till 5,000, then it shall be 15 members personally present. And if the number of members exceed 5,000, then it has to be 30 members. All of this is for a public limited company. So if the number of members is less than 1,000, then 5 members personally present will form the quorum. If it is in between 1,000 to 5,000, then the quorum shall be 15 members. And if it is more than 5,000, then the quorum shall be 30 members. And in case of a public company, it is just 2 members. Private company, it is just, the quorum is just 2 members who are personally present. Okay. Any doubt in terms of quorum? Anybody? Now, supposing, now you can ask me the question, what will happen if the quorum is not there? Okay, what will happen? So if the quorum is not present within half an hour from the time appointed for holding the meeting of the company. So if the meeting is to start at 11 o'clock, then half an hour before means 10:30. Then the meeting will stand adjourned. Adjourned means today it will be closed. It will be shifted to another day. So meeting will not be held. So it will stand adjourned to the same day. Please keep yourself muted. Shubha. Please keep yourself muted. Who is he?
मार्केट ऊपर रोइले सिना जानिबा कोडी कोन खाली बापा तो चिना पड़ते सेमति केही नाही माने
Please
चिना पड़ते अछंदी
ask
किंतु
him to keep
तो
quiet.
नेत्र तांकर का सहित कथा होता नाही
विजय लक्ष्मी मैम को होस्ट करो मैम को होस्ट करो
Vijay Lakshmi, please keep him mute. You are the host, mute him. Are you present or not, Vijay Lakshmi?
Yes, ma'am. I'm here.
निजे पूरा माने वीक करी साइलेंट जे भीतर पूरा वीक करी साइलेंट
मैम को होस्ट करो मैम को होस्ट करो
No, she can also mute Shubham. No issues about that. Thank you.
कंटिन्यू करो दी मैम
Yes. Thank you. Okay. So where was I? Okay. So it will be adjourned. The meeting will be adjourned and to the same day in the next week at the same time and same place. Okay. If not on the same, so if it is on Monday, then it will be adjourned to next week Monday, same time 11:30, same place, when you will also be the same. If not that, then to any other date or other time or place as the board may determine or board may find it fit. Okay. And there is a particular section called section 100. I'll not confuse you about that, because if I go into that, then again, I'll just point out the most important points. Okay. This is about presentation of accounts in the meeting. Okay. Audit and how it happens. Okay. Appointment of auditors and okay. Now one more thing which I have missed out in this slides. This slides I'll send you. One more thing that I've missed out in the slide is the chairman of the meeting, which is governed under section 104. Please write down chairman of the meeting. Okay. So section 104 says that unless the articles of association of the company provide anything else, that means unless the articles are saying otherwise, then the members personally present, they will elect among themselves one person to be the chairman of the entire meeting by show of hands. Okay. Because, and why is it essential to have a chairman? Because chairman is a person who is conducting that meeting, who will manage the meeting and who will ensure that the required decorum of the meeting is maintained at all times. Okay. And I also told about the word proxy. which is covered under section 105. So everybody must be knowing the word proxy because all of you have come after completion of your college. So proxy means if one of your friend is not present, you put his attendance. Okay, this is what you people know the meaning of the word proxy. Okay, but now in Companies Act also you can one member can give a proxy for another member in a annual general meeting, but that proxy will not be considered for the case of quorum. Okay, but and anybody cannot put a proxy for somebody. That is also not allowed. So basically, the proxy, the appointment of proxy is very important. It is an important right for any member or any shareholder of the company. Okay? So section 105 says that the member of a company who is entitled to attend and to vote at a meeting of the company, he shall be entitled to appoint another person as a proxy to attend and vote at the meeting on his behalf. So it is only the shareholders who can appoint. So rule 19 again, companies management and administration rules 014 comes into play. It is saying that a member of a company who is registered under section 8, he will not be allowed to appoint another person as proxy. Okay, but usually, and yes, any person who is appointed as a proxy, he has to act on behalf of the member, and or if more than one member has appointed him as a person, then he can act as a proxy for one member or more than one member, not exceeding 50. Okay, not exceeding 50, and total holding cannot be more than 10% of the total share capital. Okay? But there has to be, if supposing I have been appointed as a proxy for Mr. X, then it has to be in writing and signed by Mr. X that he has appointed me as a proxy, or it has to be signed by the attorney, and it has to be duly authorized also. Then only a person can act as a proxy. There are so many, what is that called, rules and regulations with regards to proxy. We will not go into detail, but remember who is a proxy. Maximum a person can act as a proxy. He can act for one person or maximum 50 persons, and or up to 10% of the total share capital. You can, beyond that, you cannot appoint a person as a proxy. And another important point for proxy is that, yeah, it has to be in writing and authorized. Okay. Somebody is writing something. Okay, take it. And then appointment of auditors will take place in the year. Okay. Now let's come to voting procedure. Okay. Now voting is covered under section 106 to 109. Voting can take place in different ways. Okay. One is voting by show of hands. 2 is voting by electronic means. 3 is voting by demand poll, and 4 is voting by postal ballot also. Okay, so there are 4 different ways in which voting can take place. Okay.
Ma'am, can you please repeat it again?
Okay, one is voting by show of hands. Second is by electronic means. Third is
Ma'am, second.
electronic means. Third is voting by poll, and fourth is voting by postal ballot. Okay. These are the voting rights. And remember, the right to vote is a personal right for every shareholder. And he may use it if he likes. Okay. So these are the different methods of voting. Okay. Now, voting by show of hands means you just raise your hands in favor of a particular resolution or against that particular resolution. Okay, that is voting by show of hands. So section 107, it is not necessary for you people to remember all the sections. Okay, but as much, if you can remember certain section, please remember. But if not, do not write the wrong section. Okay. So now section 107 of the Act says that unless the voting is demanded by poll or by electronic means, then the voting has to be done by show of hands only. Okay. So usually voting means it is through show of hands unless specifically demanded to be in electronic mode or by poll. It has to be through show of hands. Okay. And in case of electronic means, that is e-voting, we also call this, it was actually introduced in 2014 under the Companies Management and Administrative Act rules 2014, which gives or which allows, because in 2014 only electronic mode has been accepted. Prior to that, electronic mode was not there in the Companies Act. So over there, it provides or it gives the members in a prescribed class of shareholders of the company, they can exercise the right to vote by electronic means. Okay. And then when you are coming to electronic means, has got certain, we will cut off dates and all, I don't want to go for any details. Okay. Now, another point which I want to cover is the notice. Okay. For this voting, notice for electronic voting, because electronic voting means you can do it through electronic means. So company which provides this facility to its members for exercising voting by electronic means, they have to comply with a certain procedure for the electronic means. So over there, first procedure is a notice of the meeting. It has to be sent either by registered post or electronic means or courier. And the notice should also be posted in the website. And the notice should indicate the process or the manner of electronic voting. That first of all, that voting can take place in electronic way, and the process and manner of electronic voting. Okay, these things have to be there, otherwise electronic. And yes, one more thing, electronic voting, when is it going to open? The timing for opening of the electronic voting should also be given. Okay, And the number of the days and time shall also be mentioned in the notice. Okay? And the company also has to appoint certain scrutinizer whose job will be to scrutinize that the voting takes place properly. You all must have seen all these reality shows that takes place on TV, be it your Indian Idol or pata nahi kya kya, I don't remember all those things. But उसमें सब electronic voting होता है, ठीक है? So जब electronic voting होता है, they tell you how to do the voting. They also tell you time frame and the days and everything. In the same way, in the annual general meeting also, अगर आपका electronic voting से कुछ भी होगा, तो उसके लिए notice जाना चाहिए to all the members. Even you can give it in newspapers, and all the details have to be there. Plus, the scrutinizer has to be also just a sec, students. 1 sec. Okay, sorry. So one is a scrutinizer, as the person who the board of directors has to appoint the scrutinizer. He can be a chartered accountant in practice, or can also be a cost accountant, or can be a company secretary or advocate, or any other person, but that person cannot be a person from the company. Okay, a person of repute. So they have to basically ensure that the remote e-voting process is fair and transparent. That's the basic reason why the scrutinizer is appointed. Okay? And then, of course, the counting is done and the results are declared in the website also and to the general public. Okay? So this is voting by electronic means. Then we are having a demand for poll. Okay. So over there, members can demand for a polling or voting by poll. Okay. So if a company is having a share capital and the members present in person or in proxy, both person and proxy, and they have at least 1/10 of the total voting power, or 5 lakh, or at least 5 lakh or higher, 5 lakh or higher paid up capital, then they can ask for, or they can demand for a voting by poll. Okay, they can demand. Okay, and then voting by poll also has a lot of requirements. So I'm just telling you in brief who can demand the voting by poll. And then there is also postal ballot. So all of you have seen postal ballots where we will go and put the votes. So it is voting by post or through any electronic mode. And that provision is, now this is different from pure electronic mode voting. This is called postal ballot. So all the rules are contained in section 110. Okay, but most important is voting. So until otherwise provided, all the voting has to take place by hand. And if anybody demands, then it can take place by either electronic mode or through poll or through postal ballot. Okay. So any doubts till now, students? You can ask me questions
No.
now. Yes, any doubts? I'll pick up questions now. Because after this little bit of resolution, I'll do
Ma'am, what type of question will come?
Yes, beta.
Ma'am, what type of question will come from this?
Question can be seen from this unit. First of all, let me just check your unit. Okay. So this unit is divided into two parts. One is basically your board of directors, legal position of directors, qualification, and the disqualification, types of directors. This is one part. Okay. The second part, let me just open the syllabus. Just a sec, dear. Okay, so it can be completely annual general meeting, provisions for annual general meeting, which can contain how a notice will be given, what is the quorum, who is the chairman of the meeting, what do you mean by minutes of the meeting. Okay, so the entire annual general meeting can come. So basically, this syllabus can be divided into two parts. Okay. So one is your all about directors, and the second one is all about annual general meeting. Okay. Now there are a few small portions. Let me just wrap it up. So
Ma'am,
yes.
ma'am, please repeat that section 107 once more.
Okay. Just a second. Let me just drink a little bit of water, then I'll.
Okay, ma'am. Okay.
Ma'am, one question is there. What type of functions are performed in annual general meeting? So we have to write this general ordinary business and special business in this part or what?
Can you please speak again? I could not hear you.
Yeah, actually one question was there. What type of functions are performed in AGM, annual general meeting? In that part, we have to write the ordinary business, special business, what are the functions like this or anything else?
Yes. Okay. Ordinary business and special business. Now, what is ordinary business? All of you know. Only 4 will go under ordinary business. Then what is special business? Anything other than ordinary business, everything belongs to special business. Okay.
Ma'am,
Yeah.
can you repeat those 4 points which you have said in ordinary business once again?
Ordinary business is basically point number 1 is disclosure of your accounts. Okay. Accounts statements, consideration of financial statements and reports by board of directors. That is point number 1. Okay. Point number 2 is declaration of any dividend. Point number 3 is appointment of directors in place of retiring directors. And point number 4 is appointment of and fixing of the remuneration of auditors. These are the 4 points.
Thank you, ma'am.
Ma'am, good evening, Subrat Kumar this side. Ma'am, I just want to know one thing. Based on that ordinary, I just wanted to know financial, including consolidated, also including this statement, consolidated statement.
Which one, beta?
अभी जो आपने बताया ना 2 types ordinary and special. The ordinary में आपने appointment of directors and board reports, right, ma'am? And directors, appointment of directors, and fourth one is financials. So could you add those consolidated statement also?
Financial statements मने तमरो जो annual report बना हवा नहीं कि are you a commerce student?
Yeah, I'm commerce student, ma'am.
Okay. તમે profit and loss balance sheet सब जगह जो करूचो,
Yes, ma'am.
everything will be presented over there.
No, I got your point, ma'am. My question that recently, I mean, last 3 years, it was one that will standalone as usual consolidated statement, right, ma'am?
Yes.
So both are including this thing, right?
Yes, that will actually depend upon the
Organization.
yes.
Exactly, ma'am. Because as per my knowledge, as per AGM, that would be conducted as adoption account, there is standalone as well as per consolidated, right, ma'am?
Yes.
Yes, I just wanted to clarify that. Yes, ma'am. Got it. Thanks. Okay, thank
Okay,
you, ma'am.
somebody was asking me about section 107, right? Somebody had a doubt or something.
Yes, ma'am. Yes, ma'am. Section 107.
107. Okay. Okay, one more thing before that. Last time somebody had asked me one full question of unit 1. So in unit 2 आपका वैसा कुछ question दिया गया है क्या?
I think Barsa Misra, she was asking, and she, I'm just that time she was discussing about the second question. She has some doubt, but but there, I don't think so. They are in doubt as per my point of view. But I think Barsa was asking in that time.
Okay, so section 107 is saying that until and unless voting is demanded by way of poll or by electronic means, voting has to be done by way of show of hands. So usually that section, when it is saying like that, the basic meaning of that section is that voting will take place by show of hands. But if demanded by the shareholders, by the members, then it can go to electronic voting or by way of poll also. ठीक है?
Yes, ma'am.
And
Yes,
ये section 107 का एक पार्ट है, और एक पार्ट भी है subsection 2 में जो आता है, उसमें क्या बोला जाता है? That there has to be a declaration by the chairman of the meeting in the minutes book, and it shall that will be a conclusive evidence of that the resolution is passed, and all this is relating to voting by show of hands. Okay. And one small thing also I wanted to share with you people, जिसको बोलते हैं आपका resolution में बहुत बार मैंने कहा है resolution. So there can be two types of resolution. Okay? One is special resolution, and the second one is ordinary resolution. एक होता है ordinary resolution, एक होता है special resolution. ठीक है? So basically ordinary resolution section 114 के अंडर में आता है ordinary resolution. What do you mean by ordinary resolution? So now notice this section 114 is saying that any resolution can be an ordinary resolution if the notice that is required under this section, it has been given and is required to be passed by voting, whether by show of hand or electronic poll or anything. Okay. And in the due course of the meeting, it has been already informed. But section same 114 subsection 2 of 114 is saying that a special resolution will take place when the intention to propose the resolution as special resolution has been specified in the notice. That means any particular resolution you want to pass, you are saying that this is going to be a special resolution. You are not saying that this is going to be an ordinary resolution. Okay? And notice under the act has been served to the members stating that these 4 or 2 or 3 things are going to be discussed, and a special resolution will be passed for this. Okay, and voting can be by show of hand or by electronic mode or by poll, anything. Okay, postal ballot, anything. Okay, but difference ये है जब special आ जाता है, then you are saying, you are specifying that this is going to be a special resolution. A special resolution is anybody who wants, they cannot. If you want something to be characterized as a special resolution, then it has to be specified by at least 75% majority. And notice has to state that this resolution is to be passed as a special resolution. Okay, so
hello.
under, yes,
Ma'am,
yes,
ma'am, can I ask a question from assignment?
yes, you can ask.
Okay, ma'am, this is Varsha.
हाँ वर्षा बोलो बेटा.
Thank you, ma'am. The question is, company forms of business have become immensely popular over the years. Their development has led to the creation of so many new types of companies. The Companies Act 2013 specifies the types of companies that can be promoted, incorporated, and registered under the Act. So companies are to be classified on the basis of incorporation, liabilities, and members, and on the basis of control. Explain the above statement. This belongs to which unit?
Okay. This is
Yes,
again unit 1, basically types of companies. Okay. So what has it told? Companies on the basis of?
Companies on the basis of incorporation, liabilities, and members, and on the basis of control.
Wait. Incorporation. ठीक है? Incorporation जब आता है, दो चीजें आते हैं, public and private. ठीक है?
Yes,
क्यों पब्लिक एंड प्राइवेट? क्योंकि जैसे ही आपको सर्टिफिकेट ऑफ इनकॉर्पोरेशन मिल जाता है, देन a private company can start the work, but a public company has to wait for certificate of commencement. ठीक है? सेकेंड क्या आता है? लायबिलिटी. लायबिलिटी में आ जाता है companies limited by liability, companies limited by shares, companies limited by guarantee. So basically different types of companies. This is again unit 1 and different types of companies.
Okay,
और क्या है
thank
बेटा?
you.
लायबिलिटी के बाद और क्या है?
Liabilities and members, and on the basis of control.
हाँ, members में आ जाता है आपका public, private, 1 person company. ठीक है?
Okay, thank you, ma'am. Thank you.
Here you have to write about public limited company, private limited company, little bit of 1 person company, and जब आप लिखते हैं तो थोड़ा बहुत company limited by guarantee, company limited by shares, unlimited company in some.
Okay, ma'am. Thank you.
Oh, check. Okay, so we will end. ठीक है?
Ma'am,
Yes, बेटा बोलो.
ma'am, can you repeat chairman of the meeting once again?
Chairman of the meeting. Okay.
Yes.
So any person can be appointed as the chairman of the meeting. Okay. Who is going to appoint? It is the shareholders. With a unanimous decision, they can appoint a person as the chairman of the meeting. Appoint a person का मतलब नहीं है किसी को भी बाहर से किसी को ले आए. They will appoint somebody from that shareholders only, who is going to, or maybe from the board of directors. But it is said that with a unanimously they decide whom to appoint as the chairman. क्यों appoint होते हैं chairman? Chairman is a person who is basically he will be in charge of smooth conduct of the meeting. He will maintain the decorum of the meeting. He will ensure that whatever, because एक notice और agenda तो share किया गया है ना, क्या क्या काम होगा, तो he has to ensure that वो पूरा meeting जो भी conduct होगा it is as per the agenda and it is being conducted smooth. He is the chairman of the meeting. ठीक है?
Thank you, ma'am.
Okay. Okay, thank you all of you. See you tomorrow then.